see. Good morning.
Good morning.
Good morning. Let's see. You are here on DF 16789.
That's correct, Judge.
Okay. Let's see. And do you represent is it Calixtro? How do you say it?
Michael. Yeah, Mike. I think it's Calixtro. He's here. He can correct if it's wrong. I think it's Calixtro. Yeah.
Okay. All right. And I see that he's here. He's on mute. And good morning, Mr. Is it Calixtro?
Yes, Calixtro.
Okay, good. I got it right on the first time.
Yes.
All right. So it looks like we're just waiting on Miss Calixtro and her attorney.
A father fights back in court after his ex repeatedly denies him video calls with his children. Will the judge hold her in contempt? The courtroom falls silent as the judge calls the case, but one crucial voice is missing. Where is the mother? Attorneys scramble over confusion about representation, and tension builds as everyone waits for her to appear in this battle today.
I don't believe she's retained an attorney on this. She has one, and we have a modification going on too. But last time I talked to her attorney, she wasn't retained on the enforcement.
Oh, okay. So let me just check some things out here to see where we're at. My computer just decided to start working this morning on the bench.
Well, it's better late than never.
Oh, yeah. I was streaming from Chambers, but it's so bright in there, with all the windows. So I'm glad that I'm back on the bench. All right. So she was served. I just wanted to make sure.
Technical glitches strike the bench as the judge scrambles back online, but nothing stops the real question burning in the room. Was the mother properly served? The countdown to her fate begins right now in this tense custody courtroom drama.
Yeah, I believe 11 days ago.
So what we'll do is I'll give her 10 minutes to see if she appears, and I'll have my bailiff call the hall to see if she's here in person for any reason. And we'll just proceed from there.
Okay.
All right. Thank you.
All right. Thank you.
Okay. We're going to go ahead and go on the record. Okay. We're on the record in cause number DF 1816789. Counsel, would you please state your name for the record?
Justin Ewert for Michael Calixtro.
Okay.
10 minutes. That's all the mother has before the judge moves forward without her. The bailiff scours the hallway for any sign of her, but the clock is ticking, and time is running out fast as the case begins now.
And we are also streaming live on YouTube in compliance with the Texas Open Courts Act. The courtroom is also open for people to come in and watch as well. The hall was called by my bailiff at approximately 11:13 a.m. The respondent, Melissa Calixtro, although served with in order to appear to be present today, she did not appear and therefore will be in default. She is also not present on the Zoom. So, Mr. Calixtro, did you want to continue with your hearing, or did you want to reset your case?
Streamed live for the world to see, this Texas courtroom delivers a brutal verdict. The mother is officially in default. She never showed up, never answered. Now her husband must decide, fight on or walk away right here, today.
Continue, ma'am.
Okay. All right. So is it Ewert, Mr. Ewert?
Ewert, perfect.
Okay, great. All right. Mr. Calixtro, would you please raise your right hand?
Yes.
Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Thank you. You may lower your hand. Attorney Ewert, you may proceed.
Yeah, Mr. Calixtro, we had a temporary orders hearing in this case on March 7th, correct? Oh, you're on mute.
Yes. Yeah,
Okay.
that is correct. Sorry.
All right.
With a raised hand and a solemn oath, the father prepares to tell his truth. Every word he speaks next could determine his children's future and expose exactly what's been happening behind closed doors in this emotional custody hearing today.
And as a result of that hearing in front of Judge Lee, she made the following order, and I quote, father may have electronic video access to the children on Tuesdays and Thursdays between 7 and 7:30 p.m. Mother to provide a number for father to initiate the contact, and mother shall make the children available. Is that correct?
Yes.
Okay.
That's correct.
And that meant that your first period of phone electronic access was later that same day. Did you reach out at 7 o'clock to exercise that possession, that electronic possession?
I did, yes.
Okay. And did she make the children available?
No, she did not.
Okay.
The order is clear. Video calls, Tuesday and Thursday, 7 p.m. sharp. But when the father dials in for the very first time, silence. The mother refuses to answer. The pattern of defiance begins, and it won't be the last.
And so then the next possession would have been on March 9th. Did you do the same thing? Did you reach out at 7 o'clock and try to make that contact?
I did, yes.
Okay. And again, she did not make the children available, correct?
Yes, that is correct.
Okay. And there's been 20 periods of possession, electronic possession, since the time of that order till today's date. Has she made the children available for any one of those 20 periods of possession?
No.
Again he calls. Again, she ignores him. 20 separate chances to follow the court's order, and 20 failures. This isn't a mistake anymore. It's a pattern, and the father has had enough. He's ready to take this straight to court.
And the reason is because she doesn't agree with the court's order and she's just not going to comply. Is that right?
Well, at the very beginning, she sent me a text saying that she was working, and that was like second time I called, I believe. And after that, it hasn't been anything else. So I'm assuming that's probably fine.
Okay. And so for each one of those violations, 20 violations, you're asking that she be held in contempt and fined up to $500, correct?
Yes.
Okay. And since she's not complying, you're asking the court to order some sort of bond or security to ensure future compliance of these orders. Is that right?
Yes.
Okay.
She simply refuses to follow the judge's order 20 times over. Now the father demands justice, contempt charges, steep fines, and a bond to guarantee she never violates his rights again. This courtroom showdown is about to escalate even further.
Okay. And that you're asking the court order you additional periods of possession for all the, to compensate you for all the periods that, the 20 periods you've missed, correct?
Yes.
Okay. You're also asking the court to award you reasonable attorney's fees in this case of $1,000. Is that right?
Yes.
Okay. Pass the witness, Judge.
Thank you. Let's see. I don't have any questions for your client, Mr. Attorney Ewert. I don't see that this associate judge's report was actually reduced to writing.
He wants what was stolen from him, 20 missed moments with his children, now demanded back. And he wants the mother to pay $1,000 in attorney's fees for her defiance. The father rests his case, confident in victory.
Well, Judge, we don't have an official temporary orders drafted by either one of the attorneys in this case, but she did reduce it to writing, and I believe sign that order on, I believe, March 21st.
Yes, that's what I'm looking at. So it is ordered that father have access and possession of the two youngest children on Sundays from 10 a.m. to 1 p.m. supervised by someone selected by the mother.
Wait, was this order even legally binding? The judge digs deeper, uncovering a written version signed weeks earlier. Suddenly, the entire case hinges on a technicality buried in the court's own paperwork. One overlooked detail could change absolutely everything now.
And then there's some additional language about if the mother is unable to locate someone, but further, which is, I believe, the basis of your client's motion is father may have electronic video access to the children on Tuesdays and Thursdays between 7 p.m. and 7:30 p.m. Is that correct?
That's correct, Judge.
Okay, so what the court is going to do, because the associate judge's report, it uses the word may. It's not actually reduced to an order, which would have that enforcement language that would allow me to actually hold her in contempt.
There's a problem. The judge realizes the order says the mother may comply, not shall. One tiny word could unravel this entire contempt case. The father's attorney rests, but the outcome is uncertain. Will this legal loophole change everything today?
So what the court is going to do is, well, before I say that, Attorney Ewert, did you have any additional witnesses?
No additional witnesses, Judge.
Okay. So you're resting?
We're resting, Judge, yeah.
Okay. So what the court is going to do is clarify this order. Attorney Ewert, I would like for you, as soon as you can, to reduce this to an order so we can have the a temporary order that has the contempt language in it.
Both sides rest their case. Now everything falls silent as the judge prepares to speak. Will the mother finally be held accountable, or will a legal technicality set her free? The verdict is coming. This decision could change everything today.
You've watched what happens when people walk in unprepared. No proof, no receipts, no idea what's coming. Every question the judge asks, every document that matters. Links in the description.
It is ordered, shall, all of that kind of stuff. So then, in the event a violation occurs from either Mr. Calixto or Ms. Calixto, the court is able to entertain a request for contempt, but without the enforceable language, the court cannot hold her in contempt. So that's what I would do. The court will clarify the order so it has the enforceable language in it that these are the things that mothers shall do in order to make sure that the children are available for Tuesdays and Thursdays between 7 and 7:30 p.m. Is that clear?
That's understood, Judge.
Okay.
Judge delivers. A game-changing decision. The order will be rewritten with strict, enforceable language. From now on, if the mother violates it again, there will be nowhere left for her to hide. The rules of this fight just changed.
Okay. Let me see. How soon can you get the order drafted and circulated and sent back?
I mean, I can probably get that order put together today.
Okay. So if you will reduce the entire associate judge's report to writing, that will be good. And then moving forward, if any violations occur, at least you would have the order language there.
Time is critical. The attorney promises to draft the new order that very same day. Every hour matters now, because the next violation could finally bring the consequences this mother has avoided for months. Justice is finally within reach here.
In regards to the request for attorney's fees, I can't award attorney's fees because you didn't testify to the attorney's fees. You just asked your client about the attorney's fees. You would actually have to prove them up.
Well, I understood that. I didn't, without an objection, I didn't know if that would be necessary. I mean, we can go back on the record and I can do that. And we're still here.
Well, and see, that's the thing. I asked you, did you rest and close or have any other witnesses? And you did. So testimony is already closed, unfortunately.
Yeah.
So yes, that would be the court's ruling.
Okay.
Shocking twist. The judge refuses to award attorney's fees because they were never properly proven in testimony. One missed legal step just cost the father $1,000 he thought he'd already won. The courtroom falls into stunned silence.
I understand. All right, I'll get that circulated.
Okay, and just make sure when you reduce the order to writing on the temporary order, I'm going to do a memorandum. So just make sure that when you draft that order as well, it reads that the respondent in this case, Melissa Calixto, was made in default because she did not appear today.
Understood. Okay, thank you, Judge.
Okay, thank you. You're welcome. Yes, Mr. Calixto, you are free to leave the hearing.
Okay.
It's official. The mother is ruled in default for failing to appear. The gavel falls. The hearing ends, but for her, the consequences of ignoring this courtroom may only be just beginning. Her absence today could haunt her forever now. 20 broken promises, one furious father, and a judge forced to clarify the law. Did justice finally catch up to her?
And in an effort to stay in compliance with the Texas Open Courts Act, we are now streaming live on YouTube. Just want to let everybody know that. So I'm going to go ahead and call the docket DF22-16654.
Sorry, Your Honor. Clay Wilkinson here for the petitioner, Nabita Afrin.
Okay. All right. Are you ready to proceed?
Yes, Your Honor.
Okay. We're on the record in cause number DF22-16654. Counsel, would you please announce for the record?
Clay Wilkinson for Nabita Afrin.
Okay.
A wife testifies against her jailed husband in a shocking default. Divorce, years of family violence finally exposed in court. The courtroom goes live on YouTube. As this emotional divorce case begins, a husband sits behind bars, unable to fight back, while his wife walks in ready to finally take control of her life. This is only the very beginning.
Ms. Afrin, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down. Mr. Wilkinson, you may proceed.
Thank you, Your Honor. And I'd ask the court to take judicial notice of the contents of the court's file, which include the return of service, that's been on file for some time, as well as a prove-up affidavit, certificate of last known address, and a non-military affidavit.
Okay. The court takes judicial notice of the entire contents of the court's file.
May I proceed?
Yes.
The judge takes notice of every document on file, proof of service, sworn affidavits, and confirmation he's not in the military. Everything is in place for this default divorce to move forward fast. There's no turning back from here now.
Ms. Afrin, can you state your full name, please?
Yes, Nabida Afrin.
And you're presently married to Mohammed Hossein, correct?
Yes,
And prior to filing for divorce, you resided in the state of Texas for 6 months and Dallas County for 90 days, correct?
yes,
And you were married to Mr. Hossein on or about April 20th, 2012, correct?
yes,
And you've now ceased living together as husband and wife, correct?
yes,
And your marriage has become insupportable because of a discord or conflict of personalities that destroys the legitimate ends of the marriage relationship. Is that right?
yes,
Under oath, she reveals the truth. Married since 2012, now living apart, their bond shattered beyond repair. She calls it insupportable, a marriage destroyed by conflict neither of them could ever fix. There's no going back to what they had.
And there's no reasonable expectation that you would reconcile, correct?
no, yes, I'm sorry.
That's okay. And there was one child born during your marriage, correct?
Yes,
And how do you say your child's full name?
Afan Ibn Hossein Dihiyat.
And he's 8 years old, correct?
Yes,
And you did not adopt any children, correct?
yes,
And you're not pregnant at this time, right?
no, I'm not.
No hope of reconciliation remains. She confirms just one child was born during the marriage, an 8-year-old boy now caught in the middle of his parents' painful, unraveling divorce. His future now hangs entirely in the balance of this courtroom.
And before this divorce case, there were no other court proceedings or court orders regarding your child, correct?
No,
And
I'm sorry. Yes,
there was?
no, it was no other court.
Okay.
I have little problem with my, it's my second language, English, so I'm apologize for that.
I understand, and that's fair, and I appreciate you saying that. So if at any point my questions aren't clear, just stop me and ask so that we can make sure the answers are correct, okay?
English isn't her first language, and she struggles to keep up, but she pushes through, determined to tell her story clearly because every word she says could shape her son's entire future. Nothing will ever stop her from being heard.
So again, on that particular point, just to be clear, this divorce case was the first time there were any orders or court cases involving your son, correct?
Correct.
Okay. And your son does not own any property of any significant value, correct?
Correct.
Okay. Now, Mr. Hossein is currently in jail, right?
Yes.
And he's been there since 2020, is that right?
Yes. Yes.
And he's been there based on an incident of family violence that occurred between him and you, correct?
Yes.
This divorce is the very first legal battle over her son, and now comes the shocking reveal. Her husband has been sitting in jail since 2020 over an act of family violence. The truth behind their marriage is finally surfacing.
Where he was physically assaulting you, and then a neighbor observed that, called police, and then he was arrested. Is that correct?
Yes.
And then he's been in jail now for about 3 years pending that particular charge. Is that right?
Yes.
And during those last 3 years, and even before that, you were your son's exclusive caregiver day to day, correct?
Yes.
And are you asking, based on that history of family violence, that incident, you being his sole caregiver these last 3+ years, that you be named his sole managing conservator?
Yes.
A neighbor's phone call changed everything. Police arrived after her husband physically assaulted her, and he's been locked up ever since. For 3 years, she's raised their son completely alone. Now she demands full custody of her son forever today.
And that your husband be appointed his possessory conservator?
Yes.
And do you believe that that request is in your son's best interest?
Of course.
And as far as any visitation periods, should Mr. Hossein be released from jail, are you asking that any visitation time be only as arranged and agreed between him and you?
Yes.
And do you believe that that is in your son's best interest?
Yes.
Now, because he's currently in jail and is not able to work, are you asking that there be no child support obligation at this time?
Yes.
She wants sole custody, full control over her son's life. Her husband, if ever released, would only see him under her strict terms. After years of violence, she's not taking any more chances. This mother is finally done being afraid.
Understanding, of course, if he gets released and does start working again, you can always come back to court and perhaps request child support then, but at least not for now. Is that right?
Yes.
And is that in your son's best interest?
Yes.
And you currently have your son enrolled on Medicaid, is that right?
Yes.
And are you asking the court to order that you maintain your son on Medicaid
Yes.
and that you evenly split any costs not covered by Medicaid between Mr. Hossein and you?
Yes.
And is that in your son's best interest?
Yes.
With her husband unable to work behind bars, she's not asking for child support. Not yet. Instead, she keeps their son on Medicaid, splitting any remaining costs fairly between them both. But that could always change down the road later.
As far as any assets or personal property items, are you simply requesting that you keep what you have and Mr. Hossein keeps whatever he may have?
Yes.
And really that nothing other than personal effects have been accumulated during the marriage. Is that fair?
Yes.
And as far as any debts that may be owed, that you'll be responsible for your debts and he'll be responsible for his. Is that correct?
Yes.
And do you believe that that's a just and right division of your personal property and debt?
Yes.
Okay.
There's barely anything to divide. No shared property, no major assets. Just simple debts and personal belongings, split cleanly between them. Sometimes the fairest divorce is also the simplest one of all. This part of the case is remarkably easy.
Now, to your knowledge, Mr. Hossein was served with a copy of your original divorce petition and citation on January 11th, 2023.
Yes.
And he was served in jail, correct?
Yes.
And to your knowledge, he's now failed to file an answer to contest any of this. Is that correct?
Yes.
And are you therefore requesting that the divorce be finalized by default?
Yes.
And you have, in fact, before today submitted a proposed final decree of divorce that contains all of the items we just ran through. Is that right?
Yes.
And you signed that as well, correct?
Yes.
He was served divorce papers right inside his jail cell, and he never responded. Now, with a signed proposed decree already in hand, she's asking the court to finalize this divorce by default. Her freedom is finally within her reach.
And are you asking the court this morning to grant your divorce and approve all the requests that you've made?
Yes.
I have nothing further, Your Honor.
At this time, the court will go ahead and grant the decree of divorce. The court also finds that Mr. Hossein was served on January 11, 2023. The return has been on file since that time, and he did fail to file an answer. So he is, or even sign a waiver. So he is wholly made in default. The court has signed the decree and you'll have it back to you sometime today.
Are we excused?
Yes.
Thank you, Judge. Have a nice weekend.
You're welcome. You too. Thank you.
Hi, Ms. Rivera. Have a nice weekend.
Thank
Doing
you.
well. Thank you. See you all. Bye-bye.
Bye-bye.
Thank you.
You're welcome. Okay. Let's see.
This is it, the moment she's waited 3 long years for. The judge grants the divorce, rules her husband in default, and finally sets her free from a marriage built on violence. Justice has finally arrived for this brave mother. He's behind bars. She's finally free. Will the judge grant her everything she's asking for today?
Is it Miss Gladson?
Good morning. Yes, ma'am.
Morning. Miss Gladson. Okay. Are you ready to proceed on your case?
Yes, ma'am.
Okay.
Yes, Your Honor, we're ready.
Okay. Okay, let me just pull it up here. Okay. All right. We are on the record in cause number DF221588. Counsel, would you please announce yourself for the record?
A quiet default divorce hides a story of separation, silence, and a husband who never showed up to fight for his marriage. The judge calls the case, and everything moves quickly now. With her attorney standing by her side, this woman is finally ready to close the door on her marriage. For good, right now. There's no hesitation left in her eyes.
Yes, Judge. Ife Dolapo, last name is Amobita. I'm the attorney on record for Azanim.
Okay. All right. Would you please raise your right hand for me?
Yes, ma'am.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. You may put your hand down. You may proceed.
Thank you, Judge. Judge, first and foremost, I would want you to take judicial notice of the certificate for default judgment that was already e-filed, and I'll proceed to start asking all the necessary questions.
Okay. The court takes notice.
Okay.
She raises her hand and swears to tell the whole truth. The judge takes notice of the certificate confirming her husband's default. This divorce is about to move forward with or without him. There's no stopping this now at all.
Would you state your name for the record?
My name is Azanim Newo Gladson.
Okay, and what's the name of your spouse?
Evans Toby Lava.
And is it true that you and your spouse were married on or about August 9, 2017?
Yes, ma'am.
Is it true that you and your husband were also separated January 19, 2022?
Yes.
Okay. And is it true that his last known address was 444 St. Augustine Drive, apartment 1063, Dallas, Texas, 75217?
Yes.
Married in 2017, separated by 2022. Now she reveals her husband's last known address. The final clue needed before this marriage is officially declared over once and for all, right here today. There's no turning back for either of them.
Is it true that your spouse has been domiciled in the state of Texas for 6 months and a resident of Dallas County for 90 days, preceding the date of filing this divorce?
Yes.
Okay. Was your spouse served by a process server at his last known address?
Yes.
Okay. And did he default in responding to the petition that was served on him with a citation?
Yes.
Okay. And so I'm going to ask you some questions about the marriage. During the marriage, were any children born during the marriage?
No, ma'am.
Okay.
He was served divorce papers directly by a process server, but he never responded. And now the truth comes out. This marriage produced no children, no ties left to complicate this final split. Absolutely nothing stands in the way.
Okay. And during the marriage or currently, are you pregnant or expecting a child?
No, ma'am.
Okay. Was there any child or children adopted during the marriage?
No, ma'am.
Okay. And during your marriage to Mr. Toby Laverne Evans, were there properties that both of you acquired during the marriage together?
No.
Okay. And is there any reasonable expectation of reconciliation?
No.
No children, no shared property, no hope of reconciliation. Piece by piece, this marriage is being stripped down to nothing, and the judge is one step closer to granting her total freedom. There's simply nothing left here to fight over.
Okay. Has this marriage broken down irretrievably and due to discord or conflict of personalities that destroys the legitimate ends of the marriage?
Yes, ma'am.
Okay. And are you asking the court to allow you to hold on to your own property while he holds on to his own property as well?
Yes, ma'am.
And do you think this is a fair way to distribute the properties that were acquired by you or properties acquired by him during the marriage?
Yes, ma'am.
This marriage has broken down beyond repair, destroyed by irreconcilable differences. She's not asking for anything that isn't hers, just a clean, fair split, and a chance to finally move on. That's really all she's ever truly wanted from this.
Are you asking the court to actually grant this divorce today based on default, which means that he did not respond at the appropriate time?
Yes, ma'am.
Okay. Judge, this is all the questions I have for her.
Thank you. The court heard the testimony, accepts the testimony is true, grants the divorce. The court also finds that respondent was served on November the 4th of 2022. He failed to file an answer or a waiver, and he is in default. The order has been signed and will be sent to you today.
Thank you, Judge.
You're welcome. Thank you.
The final verdict arrives, divorce granted by default. Her husband was served back in November 2022 and simply never responded. Now the paperwork is signed, sealed, and her new chapter finally begins. This long, painful chapter is finally, truly over. He vanished. She showed up. Now the judge decides who truly gets to walk away free today.